Good evening and welcome to another live episode of Disqualified Dads. Today's topic of discussion is going to be fact finds. Now, as you know, Mr. Ryan, also known as Dan to me, will be on shortly. He will be discussing fact finds. We will be taking questions, ideally around fact finds, but ultimately, if you've got any questions around the family court, bring them. Good evening. Good
Good
evening.
evening. How are you?
I'm good. I'm good. Where you been? I ain't seen you for a week and I spoke to you for nearly a week and a half. Do you know what I mean?
I know. I appreciate the fact that you must be feeling lonely and unloved, but we've
Listen.
been
Fathers
busy.
get nervous. Fathers get nervous with that in McKenzie. The McKenzie has to be a stone's throw away, one phone call or one message away. I feel like you've been blanking me, Dan. What's going
Yeah.
on?
No, we
You've been avoiding me.
no, we endeavour to be no more than a handshake away, Farook. No more than a handshake away. But yeah, no, we're extremely busy at the moment. Family court is in utter chaos. So yeah, we are very busy indeed. But we soldier on.
Okay, Mr. Ryan. These questions are already coming in hard and fast. I've got super chats and super stickers coming in. I've even got someone already joined the stream live. They're going to
Yeah.
ask you a question face to face. Do you want to do a quick little intro before I bring him on, or should I bring him on and jump straight into it?
Let's just very quickly this evening. We're going to try and focus as best we can on fact finds or finding of fact hearings in the family court. But as Farouk has already mentioned, we're quite happy to touch on most subjects in and around the family court. I think we have got somebody waiting to come on. So what I'm going to do, we're going to jump straight in. I'll come back to the world of fact finds shortly. Let's bring in the guest and see what we've got to
Right.
talk about.
Okay, I'm going to bring in the first chat. Let's see what he's got to say. Hello, Mr. Sunny. Can you hear me?
Yeah, hi.
Right, Mr. Sunny. What do you have a question for Mr. Ryan, or do you want to tell us a bit about your situation, and we'll see how we can help?
Yes, hi, Ryan. Thank you very much. Uh, I just got this information from one of my friend. Basically, I've been separated from last three. I was separated from last 3 years now. I've been struggling. I've tried a lot to patch up with my wife, but I did not succeed. Now, we have, the divorce is almost complete by the court, but now she wants to have a clean break. But my only concern is, basically all she wanted is money. We had a separation agreement which was done by the lawyers, which was in last June, and I've already paid 50% of my house. I'm in the share of my 50% of the house. Now she wanted more money, and then in that agreement, it was decided that my son will try to come and stay with me once in 2 weeks. She said, like, we'll see how it goes. Like, I'll have to develop my bonding with my son. I've always been a loving dad, always been very good to him. But now after getting this money, she started playing off, and she's not allowing my son to meet me. It's been almost 2 months. He's not replying to my messages, and he's not answering my calls. And Vietnam, I also told her to that, we'll go through a mediation, and she denied. And now she's come back, and I got a guy who sent me a message on my WhatsApp saying that your wife needs to she wants to do a mediation. So I've attended one session now. So hopefully by next week we'll be having more sessions for mediation. But all I said was, only interested in doing mediation on finance. But I said, like, no, I also want to do on child arrangement also. But she's trying to avoid that topic. She has no interest. She's saying, no, you can't force a child. It's up to him. He's almost 15 years old. So I don't know what to do. It's like, I want my son. I want to stay with him, and I love him a lot. But I'm just going into depression. I don't know what to do. So I just need your help.
Okay. Is the mediation that you're attending, is that to do with your finances or is that to do with the child?
Sorry, come again.
The mediation that you've started to attend, you said you've already attended one session. Is
Yeah.
that to do with the child or is that to do with your finance matter on the divorce?
Basically, my wife, when I met him for the first time, I told him clearly that I want to do mediation on both, finance and child arrangement. So he's saying that your wife is interested only in finance. she's not interested into child arrangement. But I said, if she's not interested in child arrangements, then I'm also not interested, because I will go to the court and get everything legally.
Okay. Did you say your son was 15?
15 years old. Yes, that's right.
Okay. All right. Okay. Let me give you what essentially is going to be some fairly bad news.
Yeah.
The family court stops being interested in children when they reach 16 years old.
Yeah.
The family court cannot make an order on a child who is 16 or over. So, and because of the delays in the family court, if you made an application into family court tomorrow in order to
Yeah.
see your son, that
Yeah.
family court proceeding would not be anywhere near complete before your son was 16. And at that point, he can decide exactly what he wants to do. So in terms of a child matter, unfortunately, your son is too old for you to go into family court, because you would just be wasting your money. You are going to have to try and engage with your son some other way, or hope that in the fullness of time your son makes contact with you. In terms of the finances, it's no surprise that obviously you thought you'd made a deal, and your ex-wife is coming back and chasing some more money. If you're still outside court with that matter, and it sounds like you are, it sounds like you've got solicitors trying to sort it out between them. It's highly likely that you're going to end up in court in order to get a court position on that and get the court to decide on your behalf. So neither of those, I appreciate, Sonny, that neither of those are good news. The other say, because unfortunately the child matter, your son is just too old, and the finance matter, solicitors will go backwards and forwards, negotiating and renegotiating, and all the time, all they're actually doing is running up a bill that you and your ex-wife are going to have to pay. Just stop negotiating. Say, if we can't reach a sensible decision, let's take this matter into court and get a court to tell us what to do.
Sonny, what do you think? Sonny, are you there? Sonny, does that answer your question? Yeah, just give him a sec. He might have some bad reception. So. Right, yeah. Sonny has been disconnected, unfortunately.
Okay.
Right. Sorry, Mr. Ryan. Before you move on, we've got someone else here. Should we bring them on quickly as well?
Yeah, sure.
All right, Sonny's back.
Oh, good.
Call, so got this. The volume was very less. I'm so sorry for that. Apologize.
That's okay.
Yes, so Sonny, did you hear obviously Mr. Ryan's answers? Yeah.
I could at the end there was a little bit. I could not hear at the end. So sorry.
Okay, so essentially where you are, Sonny, is that your son is too old for you to start financial proceedings. If your son is 15 now, which means within the next 12 months, he's obviously going to be 16 years old, there is absolutely no way that the family court is going to be able to manage a child situation for you in less than 12 months. They just can't do it. They're just too congested. Hearings are taking 18 months to 2 years as an absolute minimum in child proceedings. So by that point, your son will be approaching 17. So the court will not be, the court just won't make an order against him. So your son, unfortunately, you're going to have to try and re-engage with your son or wait for your son to come back to you. And in terms of the finance matter, it sounds like you've just got two sets of solicitors who are running up their own fees whilst going backwards and forwards trying to negotiate a position. I suggest you advise your solicitor, if you're still using one, to stop messing about and take the matter into court and get a court decision out of it. That is just the quickest way you're going to deal with your finances now.
Yeah, Sonny. Sorry. Yeah. Go on. Go on, Sonny. Go on.
So basically, she was trying to do this amicably, where she doesn't. First she said she was demanding money. Now she doesn't want anything. She just wants a clean break. But I was into my mind that because this is what in the separation agreement, which was done in last June, she said you try to bond your relationship, and I'll try to say we'll see how it goes. But once she got the money, she just totally changed herself, and she's not allowing my son to meet now. So I was just thinking, how, and what is the best? What shall I do? Like,
so you've given her the money. You're saying you did you give over the money? You're saying, yeah.
I've already given, yes.
Right, so that's done.
Then you need to instruct your solicitor to draw up a consent order for you. Get that submitted. He'll know what that is. A financial remedy consent order. Tell him to get that submitted into court as quick as he can. and get the clean break that she wants and that you need, and end the matter.
Okay, good.
Sonny, I hope that answers the question. Sonny, don't give up, keep going, yeah, and thank you for joining the stream.
Thank you very much. I appreciate it. Thanks.
Okay, thanks for your time, Sonny. Now
Right.
I'm gonna do one now, Farook, before we do any more.
Go on.
Because it's very rare that people actually contact us direct, because normally obviously they come through you, but I have had a message direct to us, which I'm just going to very quickly deal with. It's come from one of our followers on Instagram, and he says, can Ray Judicata, and I'll explain what that is in a minute because that's from a previous stream, be utilised from hearing to hearing in the same proceedings, or only after the proceedings have been finalised? Right, so let me explain what Ray Judicata is. Ray Judicata is a legal term that means that an issue that is being raised in court has already been dealt with and settled previously, such as, classic example is an allegation. An allegation gets raised, it gets dealt with in court and settled by one way or another. And then 3 hearings later, suddenly it's being raised again because we think there's a bit more mileage in it. And you declare to the court through either through yourself or through your support mechanism, that is an episode of Ray Judicata, which means we've done this before. We can't do this again. You can't keep revisiting the same allegation. That is outside the law of this country. And to answer the question that I've been asked here, yes, you could do that from hearing to hearing. So if you've had a hearing, you've dealt with an issue, and at the next hearing they raise the issue again, you declare Ray Judicata, the judge will agree with you. If at the next hearing they raise it again, you declare Ray Judicata, the judge will agree with you, and the matter will be flattened. That was quick, and I've dealt with it.
All right, sweet. Right,
back to you.
Right, I've got another guest, Dan. While he's here, let me, or it might be her, let me bring them on. Let's see what they got to say.
Okay.
Right, Stevie, if that's your name or not, yeah. Introduce yourself or ask us your question.
Thank you. So I just want to give you some background, and it is really about whether there's any point in having a fact find. So I had a Section 7 done. So I've got 3 children, and I'm only seeing one of them 50% of the time. I had a 50-50 agreement that was from a Hedra. That was 4 years ago, and there's been parental alienation with my eldest 2, so I don't see them. But my youngest one has insisted on still seeing me, which is just amazing. And I haven't heard from the elder 2 for over a year now. So I've sent them presents, I've sent them letters. I've had a Section 7, and the Section 7 was very favourable towards me. I've got a hearing on the 21st of August. And Mother has done lots of, besides alienation, she's been arrested, but there's no further action. She's made lots of false allegations, including 2 social service departments and also the police, to say that I was molesting the child that I was seeing, my daughter. That there was no evidence of that. And there has been a series of allegations that have been made against me that have not been proven, and she's never wanted a fact find. And I was wondering, is there any point of me actually asking for a fact find, because there's been so many allegations over time that she's never had to stand up and make an account or provide any evidence, but it has actually made my position much weaker over time. Originally, I put in for a non-molestation order under prohibitive steps because I suspected, well, she threatened me, she'd hit a couple of the kids, and this was 4 years ago, and the kids' passports had disappeared, and her passport had disappeared, and I thought she was going to do a runner somewhere, so she's not from this country originally. So I did an ex parte hearing in which I got the non-molestation order and the prohibitive steps, and then a week later the judge didn't believe me and put a non-molestation order on me, so we had cross non-molestation order. and he said you can go back into the house where we were both living, and she'd been ejected from the house, but she then came back. And to cut a long story short, there was a series of allegations. So when we were in court for the second time, after she'd been ejected from the house with the non-molestation order, she said that there'd been rape through the marriage, and there's been all kinds of allegations that have been made. And I just think, we've got a child arrangements hearing on the 21st of August. We've done the divorce. It's been a very messy divorce, but we've done the divorce, but the children's issue still is outstanding. And I'm kind of sick of all these false allegations. And I also think there's quite a bit in the Section 7 report that points to mother actually stopping the kids from seeing me. I mean, although it was an independent social worker said that there was no evidence of alienation, the social worker is actually a safeguarding social worker, and I pointed out alienation. She didn't understand really the top and bottom of it, and I gave her the CAFCAS, from the CAFCAS website. I gave her the documentation around alienation, and that's how she decided that there was no evidence, but she didn't really investigate it. So that's one of the issues that I'm going to deal with in the court. But I don't know, when we have the child arrangements hearing on the 21st of August, at what point do you say, I want a fact find, and is there any point? Should I just anticipate, because my kids, I've got 3 kids, one is 16, so obviously from the previous speaker, it's very clear that the court aren't going to rule on him.
Yeah.
I've got an 11-year-old who will be 12 in November, and I think it hinges on her and the youngest one who's 7. And the youngest one who's 7 have an interim child arrangements order that says she should continue with me 50-50, and the independent social worker has absolutely agreed and said yes, absolutely. There's no basis of the allegations that mother has made. And it's really, sorry, go on.
Is it the youngest one that you're seeing currently, Steve? Because you said you're seeing one of the children.
Yeah. So the youngest one.
Okay, all right. So your hearing in August is primarily in order to review the Section 7 and get the perspective, your perspective, mother's perspective, and the court's perspective on it.
Yeah.
Yeah. Okay. All right. So let's dive into your question then about fact find. You can suggest a fact find. You can ask for a fact find. The court obviously has to, believe that it is proportionate. And there are 3 questions that you need to ask yourself before you push forward and say, I want to ask for a fact find. And those 3 questions are the same 3 questions every time we entertain a fact find. Number 1, is it proportionate? I.e., is it worth it? It is, because you are basically going to lose another 6 to 7 to 8 months of your hearing proceedings waiting for a fact find to come around, then for a fact find to take place before you then get back on track again with your child matter. So you are going to lose time. So is that proportionate? Issue number 1. And the court asks the same question, is that proportionate? Issue number 2, what happens if I win? What do I gain if my allegations are proven to be true? What do I gain? In terms of my children, not in terms of just scoring points. What do I gain in terms of my children and the welfare of my children? And then question number 3, and this perhaps is the most important one of all 3. What happens if I lose? Yeah. What happens if the allegations, because if you make allegations, there will be cross allegations. She will make allegations against you. So what happens if I lose? What do I stand to lose? And this is really where we get into the bulk of fact find. Nobody ever wins a fact find. Nobody ever wins. If allegations are made in fact find, doesn't matter if there's 10 allegations or 110 allegations. If allegations are made, at least one of them, as an absolute minimum, will always be found to be true, or proven is the phrase they use. So one will always be found to be proven. So by that virtue, if you start a fact find, you are going to lose one. Because she's going to make an allegation against you, and you may dismiss 9 of them, but one of them is going to be vague enough, woolly enough for a judge to say, well, actually, that probably did happen. So you need to bear that in mind. So those are your three questions. Is it proportionate? Because I'm going to lose a chunk of time in terms of these proceedings because of how long it takes to, because fact finds invariably are at least 2 days. So you're asking a court to find when they've got 2 consecutive days in the court diary. And if you look at the London courts, you can wait up to 8, 9, 10 months for that to take place. If you look at the northern courts, and I don't know where you are, Stephen, it's not wholly important. But if you look at the northern courts, you're still waiting between 5 and 6 months in order to find a date for a fact find, particularly if you want 2 days or more. I've just had this literally this week. I've just had a fact find listed. It's very necessary. There's a whole series of issues. We've had it listed for 4 days because there's a whole lot to go through. It's been listed for next February. That is the first time that we can get back in court. So both parties in that matter are losing the thick end of another year before they can get to the fact find. So you've got to ask yourselves, is losing that time worth it? Am I going to gain something, accepting the fact that I'm going to lose that time? What happens if I win? What does that do in terms of my relationship with my children? And in terms of your specific relationship, we're going to get onto alienation in a minute. What happens if I lose? And the impact of lose in the world of fact find can be massive and wholly unjustified, in my opinion, but can be massive. So the other point you mentioned was parental alienation, and you mentioned the social worker. So let me just understand, Stevie. So CAFCAS have subcontracted the Section 7 out to an independent to do it for them?
No, in fact, I submitted a C2 and made the argument that rather than having CAFCAS, it would be quicker to have an independent social worker.
Paid for
by me.
Okay.
So I paid for the Section 7 report, and I found the best independent social worker that I could. And on the whole, it was a favourable report. It called into question a lot of what Mother was doing.
Yeah.
The only thing was the social worker didn't really rely heavily on any alienation that I'd mentioned.
Sure.
So, but she points to it throughout her report.
But says there's no evidence of it.
Yeah. But I mean,
that's probably because she doesn't understand it.
Yes, exactly.
I think that's probably the issue there. Okay, so let me just stick with the independent and the fact that you paid for it, just out of interest. When was the hearing where they ordered the Section 7?
The hearing was in December.
And the next hearing is August.
Yeah, so massive delay.
That's a massive delay, yeah. I'd have left CAFCAS with it and let them pay. But anyway, I appreciate why you tried, and it was a good effort.
Yeah, I mean, basically, we got the Section 7 at the end of March, and then we got notification that the next hearing was going to be in August. Just ridiculous.
Yeah, and that's just dreadful. Yeah. Okay. All right. So parental alienation is a huge issue. Parental alienation is a massive issue in family court, and it's becoming a greater issue on the fact that family court is doing their best to ignore it, and is doing their best to suggest that it doesn't actually happen, doesn't exist. And so that makes it awfully difficult. And the problem we have with CAFCAS officers, and certainly with independent social workers, is that there aren't many out there who've got a huge understanding or a huge inclination to understand parental alienation. We've got some live cases at the moment which are very clear examples of alienation, and some of them pretty extreme. And we're not just fighting the parties in that matter. We are fighting CAFCAS and the courts to get them to recognise the issue. So I appreciate your difficulty, Stevie. So you've got 3 children, as you say. 16-year-old has dropped out the mix, unfortunately, because of their age. The 11-year-old is currently being influenced by Mother, from what you say, and the youngster, bless, is having time with you, but Mother is doing everything in her power in order to frustrate and thwart and try and destroy that time.
Exactly. Yeah.
And that, unfortunately, that will continue until August. Do I think you should have a fact find? I think you should actually talk to CAFCAS about it, which you can do between now and the hearing, because CAFCAS will have had a copy of your independent social work report. So I think you should go back to Kafkas and say, look, I have increasing concerns about obviously the allegations. I'm looking for a view from Kafkas as to whether they believe, that a fact find is going to assist us here. And that having that second opinion would be useful to you. Because obviously I've got half an idea of what you've described to me, but I don't know the full details of the case, so I can't give you my reasoned view on it. But all I say in the world of fact find is just tread carefully. Massive time delay, and what happens if you lose?
Yeah, exactly. I think it's very interesting that you've brought up Kafkas. I didn't realise that I could actually go back to Kafkas and they would review the Section 7 report. And then, because I think they would be able to help in interpreting what has been written and see that there are actually very strong indications that alienation is going on.
Yeah, Kafkas will, because obviously you went outside and had it done outside and paid for it privately. Kafkas' initial response, it's nothing to do with us. But unfortunately it's a live child matter. You've happened to use a subcontractor to do the job, but it's Kafkas who will have to carry that report in court and beyond. So you can go back to them and you can get them involved.
Good stuff.
That's really helpful. Thank you very much.
All right.
Stevie, I hope that's given you some information. And also, this is the point of the stream. You've walked away with information that you didn't know before, which is going to help you. And Stevie, keep going. Looks like you put up a good fight. So keep at it. Keep chipping away. Do not give up.
Appreciate it. Thanks, guys.
No worries.
Take care,
no worries.
Stevie.
Right, Mr. Ryan, before we continue, I just want to read out a couple of super chats, got a couple of questions in the comments, and then we can try and get back to the fact-finding element of it. Right. So firstly, shout out to, I don't know how to pronounce it, COSSIEP, COSSIP, £20 super sticker. Appreciate you, my man. Thank you. Appreciate you. Also, we've got a £100 super chat from Mr. Patel. Respect to you. Let me read out his comment. Thank you, gentlemen, for being advocates for fathers. Keep educating current and future dads. Your work will be blessed by God. Amen, my brother. Amen.
Absolutely.
You.
Thank you. Yeah, thank you,
Mr.
Kashi.
Patel.
We appreciate that. We appreciate that.
Right. I've got a couple of questions here, Mr. Ryan. I'm going to jump onto it straight. Right. Tim Wiltshire. How do you get a fact-finding reheard out of time when new evidence becomes available?
With difficulty, Tim, to be perfectly honest. I'm going to second guess from what you've written. You've had a fact find previously. It's gone for you or against you, probably against you, given that you want it to be reheard. You've now got some new evidence, and you're going to try and get that reintroduced back into court. If your proceedings are still live, so if you are still in the same proceedings where the fact find took place, you can make an application to court under a C2 in order to introduce a fresh position. So you go back to court using a C2 application, you say, look, I've got something new that I need to add to the mix. Will a judge reopen a fact find? It's rare. I'll be perfectly honest. It's very rare. But they will listen to new evidence if they believe that new evidence is impacting on the welfare of the children. Once the fact find is done, the court's almost sole concern, once they've labelled people with a fact find, their almost sole concern is the welfare of the children. So if your new evidence impacts potentially on the welfare of the children, see to it, get it back into court and get a judge to listen to it. Perfect.
Tim, I hope that answers the question. Right, next question from someone with the initials SA. If you have a PTR a month before a fact find hearing, can you propose if a fact finding can be avoided if Kafkas initially recommend a section 7 in their report if all court orders being followed?
Right. Okay. So we'll just unpack that to make sure we understand it. So a PTR, which is a pre-trial review. So often before a fact find takes place, we have a 1 hour, very short hearing, and it's for the judge and for the parties to understand what is going to happen at the fact find. Are there going to be witnesses? And if they are, who are they? Is mother going to be cross-examined? If so, by who? Is father going to be cross-examined? If so, by who? Will Kafkas be in attendance? They're not usually at a fact find, to be honest, but sometimes they will be brought in. Have we got anybody else who's coming into the mix who's going to be listened to? the question, can you avoid that? Can you avoid a fact find? Unfortunately, if you're already going down a PTR, the judge has already made his decision. The court has already made his decision that the fact find is going ahead. Your opportunity to object has passed you by. If Kafkas said in their section 7 that they wanted if Kafkas said that they wanted a section 7 rather than a fact find, the reality is the section 7 will come, but it will come after the fact find. The judge clearly sees that there are allegations here that he or she wants to explore and get out of the way because he believes that it's going to impact on the welfare of the children. So what will happen is fact find will take place, and then the judge will then instruct and direct Kafkas to carry out the section 7.
SA, I hope that answers a question. Comment from Mr. Christian Kumar. Can you increase the video quality to 1080, please? Yes, I will do once I get a bit of money. As these super chats build up and people start donating to the link, I can go get another camera. So, yeah, in time we will be. Right. Another question. I'll quickly just jump onto these, Mr. Ryan, get them out of the way. We got Q from Ted D. Q previous. So Q, I'm presuming question. Previous C100 child arrangement orders. The father submits another C1. So let me read that again. Previous C100 child arrangements order. The father submits another C100 to the court. Will it always go to a section 7? And is there anything to submit for first directions hearings by the papers? Come on.
Right, okay, let just
brackets.
I'm going to second guess a little bit as to what this means. I surmise that there is a previous child order in place and that the father has now essentially started the process again by banging another C100 in, either because he's seeking a whole new order or because he's seeking a variation of the order that's already in place.
Mm-hmm.
That's what I presume we're asking, the question we're asking.
Makes
If we're
sense.
asking that, what will happen is the previous proceedings, so all the papers from the previous proceedings where the initial order was made, will be consolidated, will be brought into these new proceedings. So nothing will be left out. There'll be no secrets. You can't start again. You can't hide stuff. Whatever happened the first time round will be seen the second time round. Will that go to a section 7? It really just depends what the first time held, and also what the premise is that father's making his application on. If he's making an application just because the child order isn't working, he's not getting enough time, perhaps, or in his opinion, he's not getting enough time, it isn't necessarily going to go to section 7. That may be something that's dealt with at a local level by a judge, but without a bit more detail, we can't say. But second time you go to court, third time you go to court, every time you came before gets consolidated into that proceeding.
Okay, I hope that answers the question. I'll jump into the next question quick, Mr. Ransom. Yep. Just polish these off quick. Take your time, I mean, not quick, but let me just get on top of these and then we can carry on. Right, question from Beam. In regards to financial court, I'm on my second hearing. My wife's using our child's autism to stay in the house. Am I with any chance to have a sale of the house as she now wants a measure order? Measure order.
Okay, so a measure order, just so we all know what that means. A measure order is an order that the judge will place on a house to say that until such times as the youngest child is out, and it's usually out of full-time education. Until the youngest child is out of full-time education, that house is ring-fenced. That house has got a mesh fence around it, hence measure. So in your case, again, without more detail, very difficult to say, but it's not guaranteed. Measure orders are very rarely put in place by the court because the court appreciates that a measure order, whilst safeguarding one party, has the potential to financially totally destroy the other. And so they're not big fans of measure orders. So you have the argument or you have the opportunity to argue that point in order to have that removed and avoid having that put in place. It's a very difficult thing for somebody to argue in court to get a measure order. They've got to have some pretty extreme circumstances. And with all due respect, your child's autism is probably not extreme enough.
Okay, so the question I'll ask on the back of that, Mr. Ryan. So, this measure order, if you did end up in court where the ex is trying to get this in place, if you turn around and just say to the judge, look, because presuming the person that's left the house, father, 9 out of 10 times, is still paying the mortgage potentially, and that's why she wants to stay there, because being paid, isn't it? If he says, well, look, I can't afford it, I'm not going to pay, it's going to decline, it's going to get repossessed anyway, can that be used as an argument against that measure order? Say, listen, she can have the order, but it's going to get repossessed, mate.
Yeah.
If you don't sell, it's getting repossessed.
Yeah. There has to be. That's one of the biggest issues for the court, is that people come in and say, I want a measure order, but I don't actually want to pay the mortgage. I want him to pay the mortgage or her to pay the mortgage. I just want to stay in the house. And the court, there has to be a reality to that. So the court will often say, well, yeah, if you've got a measure order, who's paying? How's the house going to be maintained? And if you're going to tell me that, well, I don't intend to pay, I just want to live there for free for the next 6 or 7 years, that isn't going to happen.
Yeah, sounds familiar, Mr. Ryan. I'm just getting deja vu when you said that. Yeah,
I'm getting a deja vu moment there. Yeah.
Right, got another question from SA. If someone is on benefit, how does one afford a contact centre if an order of that is such is given? If a order of that such is given, can you propose asking to meet with the paternal grandmother if they allege safety concerns?
Okay.
Do you get that? Shall I read that again?
I've got that one. Right. Okay. So contact centre. So the court has decided that for whatever reason, for you to see your child, you need to see them in a contact centre, and there is a cost to a contact centre. Contact centres are anywhere, depending on where you are in the country, anywhere from £50 or £60 an hour to £120, £130 an hour. So it really does depend where you are. The court expects whoever is going to the contact centre to see the child, the court expects them to pay. If you're on benefits, the court doesn't care. The court expects you to pay if you have been ordered to go into a contact centre. And if you cannot afford to pay, and you cannot strike a deal in court where perhaps the other party pays half as well, so you help each other out, how likely is that? Then the reality is you're not going to get contact. The court's position is very plain. There's a contact centre. The court doesn't really care. There's a financial position on it. We've issued you with a contact centre. After that, it's your problem. Can you try and change that, which is the other part of your question? Can you try and move it out of a contact centre and put in place somebody like the paternal grandmother in order to essentially supervise you? I surmise that's what you're asking. Yes, you can propose that, but I can guarantee that the party, this is paternal grandmother, so either mother or father, whoever it is who isn't in a contact centre, is going to disagree. And they're going to say that that is not appropriate. If you're the father and you're asking, which possibly you are, if you're the father and you're asking if your mum, the children's grandma, the children's grandmother, can essentially supervise contact, mother's going to say no, and the court's going to say mother said no. Because parties have to agree on a third party supervisor. You're back at the contact centre. And I appreciate the issue about obviously the cost of a contact centre, because they are astronomical.
Well, there's a couple of things that I would like to pull you up on that, Mr. Ryan. You said the courts don't care. You said the courts don't care. How dare you make a statement saying the courts don't care? The courts definitely care about fathers. They love fathers.
I feel guilty now that I've said the courts don't care. I kind of hope not to mention that. But yeah,
we should be in a contact centre game, I think.
The courts don't, unfortunately, the courts don't care. But yeah, the courts don't concern themselves with costs. You know, they don't. It's just not something they worry about, to be fair.
Right. Okay. Right. Blondie 15. I'll bring you on shortly. Just bear with me. Got another question coming, Mr. Ryan. Let's just jump on them as they're coming in.
Yeah.
How powerful is a written agreement of arrangements to seeing children, but then the mother decides to go back on her word? Would that written agreement take preference?
Okay. It depends how that written agreement was formed. If you and mum, is it mum, isn't it? Yes. So if you and mum sat down and drew something up between you about how it is you were going to manage the children, that piece of paper, the moment that one of you disagrees with it, is not worth spit. If you and mum draw something up and you both had solicitors involved, so the solicitors essentially drew up that document between them, and the pair of you sign it, That then becomes a little bit more weighty in terms of its ability. Oh, look out, we've got a bloody hell from HG. Yeah, bloody hell, I'm sorry, HG, I've ruined your night. Yeah, so if you've got solicitors involved, it has a little bit more weight. But essentially, the problem with agreements, unless you have a court order, the problem with agreements is one side can just say no.
Okay, can you apply for a consent order on the back of that agreement or not?
Can, yeah, as I say, one of the things that we do here at McKenzie Picave is that we draw up orders for people. So we draw up, legally binding orders, children's orders about how parents can manage their children. And then we take that into court and we have it signed off in court as a consent order and issued to both parties. So yes, you have a written agreement, but it's got a court seal on it. And at that point, it is legally binding.
Yes.
But if you've drawn something up between the pair of you while you've been sat in the Tesco's cafe one afternoon, I'm sorry, it has absolutely no value.
Yeah, unfortunately, guys, anything that the fact is, whoever has the children holds all the cards, and they can pull the rug from under any given time and moment. And listen to the calls tonight. Again, I will reiterate to fathers: this is a marathon, number one. This ain't a sprint. This is a marathon, and you have to tackle the marathon. You can't just go all out at the first 100 meters. Yeah, you've got to be strategic. So all of these things come back to strategy. The call we had earlier regarding the chat and the section 7, strategic. Do I need this? What will it give me? How will it affect my access? So you got to tackle family court strategically. It's a marathon, not a sprint. Right, Mr. Ryan. Got no questions now. Blondie 15, bear with me. I'll bring you on shortly. Right, carry on, Mr. Ryan. On the why we're here today.
So the world of the fact find. So why do courts decide they want to take a fact find? I'll tell you what they do is if there are sufficient allegations, and those allegations can be just from one side against the other or firing backwards and forwards across each other, the court will decide if we as a court explore these allegations to decide if we believe they are true or not. Will that assist us in trying to sort out the children? That's the question they ask. So if the allegation is that 15 years ago, before the children were even born, I cuffed her across the back of the head one afternoon, and then she punched me squarely in the face, it's highly likely that the court will say, well, that really has no bearing. You're a pair of idiots then, but that really has no bearing on this matter. So the allegations have to have some point to them in terms of the court believing that they are either relevant to the children because the children are involved, the children saw them, or you're hitting your children, don't be doing that, or they believe that they indicate a behavior that possibly will impact on the children because you are being physically abusive, emotionally abusive, coercive, controlling, whatever it may be. So the court decides we need to essentially suspend the child matter and take on board a fact find. 1 day, 2 days, 3 days, 4 days, depends on the number of allegations. So we will put the children's matter to one side and we will find ourselves 2 or 3 days of court time, and we're going to wait months and months and months for that. And then we are going to test these allegations. In the family court, the fact find is as close as you will ever get to a trial because you are being accused. And the evidence against which you are being accused is tested. But here comes the rub. In criminal court, you are tested by a judge, and that judge is assisted by various legal people prosecuting and various legal people defending. And invariably, it's assisted by a jury. And that jury of 12 good men and strong will listen to what you've said, and then they'll retire to a room, and over the course of an hour or a day or a week or a month, they will decide if they believe that you are guilty of those crimes. Family court doesn't work that way. Family court does not use the criminal threshold. Family court uses a system that they call the probability of balance. And let me explain that in the simplest way. You have got a seesaw. There you go. We remember them from when we were kids. So you've got a seesaw, and currently it is perfectly level. The judge has to decide by listening to the evidence that allegation is moved one way in favour of mother or the other way in favour of father. So it's either proven because mother said it happened, dad said it didn't, or vice versa. But it has to move in one direction or another. But now here comes the rub. It only has to move 1 point. It sits at 50-50. So there's 50% chance that it's right, 50% chance that it's wrong. It only has to move 1 point. So it only has to move to 51% versus 49%, and it is proven. So all you have to do, and look out, here comes the secret of a fact find. All you have to do in a fact find is be able to instill doubt in the mind of the judge that, well, maybe it did happen. I can't be sure, but maybe it did happen. You just instill doubt. And remember, in the family court, you're in a fact find. There's no jury. There's a judge. The judge listens to everything you say when you've been cross-examined, everything mother or father says when they've been cross-examined, everything that any witnesses say when they've been cross-examined, and then the judge digests everything they've heard, and they make a decision on each and every allegation. Allegation 1, you hit your wife around the back of the head one afternoon because she wasn't listening to you. I think that allegation is proven. Allegation 2, she punched you squarely in the face when you came home one night because you were 10 minutes late. I don't think that happened. Allegation 3, and so it goes on, and so it goes on. But just think for a minute. All you've got to do is instill doubt. So fact finds are not about, in my experience of many years, fact finds are not about truth. They have a part to play, but it's not much of one.
It's irrelevant.
The fact find is about he or she who delivers the best story and convinces the judge or instills sufficient doubt in the judge that they will rule in their favour. I have had some farcical examples of incidents that apparently have happened, which could never have happened ever, not even in a movie. And I have had a judge then rule that, yes, that definitely happened because the person telling the story cried in the right place, felt distressed in the right place, and was clearly traumatized by what happened. I mean, mad stories. Where you think there's no way in this world that happened, and there's no way in this world that anybody with any degree of common sense will accept the fact that that happened.
But why is this accepted in family? Of all places, in family court, they believe stories that could never be believed anywhere else, any other institution, any other organization, even in soaps, right? You know, even on EastEnders, some of these stories are so far-fetched, they won't even make EastEnders. So why in the family court do they believe, somehow they believe it? How?
Because they have this principle that they call the probability of balance, and I only have to move that judge's opinion 1 point. That is all I have to do. I have to move his opinion 1 point, and then that allegation happened. That is all. And 1 point is a decent set of tears.
Oh, flip that. Maybe we shouldn't be giving this away. Maybe this information shouldn't be given away. Maybe shouldn't
be telling you this.
Backfire. This will backfire.
Yeah, so that is the issue with fact find. Fact find is a dangerous place to be, and I know we've talked before about non-molestations being dangerous, which they are. Fact find is a dangerous place to be because the reality is this: if you have allegations against you in a fact find, you will never get away, and that's what it boils down to. You will never get away with all of those allegations being proven as not having happened. It is just not going to happen. The odds of you being able to get a clean sheet is nil. One of those allegations is going to get proven against you. And the moment that allegation is proven, your world changes fundamentally, because suddenly in the family court, you are a man or a woman who has findings against them. And those findings are hung around your neck like the bell of a leper, and they will stay with you for the rest of those proceedings.
Yes, fact findings are best avoided completely. I think obviously
they are best avoided. As I say, if you can deliver a decent enough argument as to why a fact find is disproportionate, i.e., not needed, if you can deliver a decent enough argument on that, and it has to be a blooming, I'll use that, has to be a blooming good argument, do so. Do so. Say to that judge, spending time dealing with this and working out what happened 10 years ago, 15 years ago, 5, 6, 7 years before the children were even born has no relevance to this. It has no relevance. Asking me what I was 10 or 15 years ago and what I am now as a responsible father or a responsible mother, we are worlds apart. Because we were all young once and we were all stupid once. It has no proportion to what we are trying to decide here. Deliver that argument to a judge and get him to take it on board and avoid a fact find. You're in a far, far, far better place.
I'm saying you're right, Dan. I think we must have been young and stupid because we got married.
Well, at the time it was a wonderful, wonderful thing.
Right, Mr. Ryan, I've got Blondie 15 here.
Yeah.
Wants to join the stream. If I remember correctly, she's a McKenzie, probably from your neck of the woods. So I'll bring her in for a quick chat.
Yeah.
Hiya.
You okay?
Hi.
Yeah.
It's not so much a question. I just want to kind of add a bit of detail into some of the answers. I'm not kind of disputing them, but with Beam, you're right in what you're saying. There's not enough detail to use, but there's an argument to say that if you share the care of the child, both housing needs are equal. So that would go in his favour to say she doesn't have the right to remain in that property. So therefore, that house should be sold and we both have equal needs to use that money to obviously get another house.
That's true.
With SA, I don't know the circumstance again, but I think if it is the situation, you could present a strong argument for contact being borne by mother's legal aid. If they want it, you can argue, well, they want it, why should I have to pay for it? And there was just, again, off the back of the whole fact-finding thing, what people have to be mindful of, the person making the allegations, it's their responsibility to prove them. So I always recommend to my clients, obviously don't go overboard, but if you can provide enough evidence that disputes the other person's allegation, then it's highly likely that on the balance of probability, it could be that it will not be found.
Okay, that's some good input. Great stuff. Yeah.
Yeah, I just like I say, I just wanted to kind of give a few people a bit more information from that.
No, that's great. No, thank you for your input. That's great. All the information and knowledge, the better. Yeah, I appreciate you joining. Thank you again, and
thank you.
Join again.
Absolutely.
There you go. We got a bit more info there. What do you make of that, Dan?
There we go. Yes, yeah. I must. I have to. I didn't recognise that lady, but maybe I should. Yeah, no, she's absolutely right. Very valid points. Very valid points.
Right, Mr. Ryan, Mr. HG here has got a few more questions. Right, the first one I'm going to read it out, and I might try and tackle the first one. I think you just nod if you think if that's a right course of action or not. About to say too much, right? Yeah. You got to show your face in court at some point. Yeah. Right. Before marriage comes to an end, but you're feeling marriage will end up in divorce, what is the best way to prepare, and what types of receipts would you recommend we keep? Now, look, I'm going to tell you this. Let's call it off the record because I'm not a court guy. I'm not a McKenzie as such. If you are still in the family home, you are still a parent. And like we know now, the one who takes control of the situation by taking control of the kids is the one who controls the game. So my policy is always, if you think it's all going downhill anyway, you should be recording, logging everything, any sort of negative behavior or abuse, anything like that towards you. You should be logging time, date with evidence. And also, if you feel the end is near, you're still in the family home, you've got rights as long as you are still in the family home. My suggestion is you should take the kids in the car a couple of weeks for a little holiday. go for a couple of weeks, little holiday, disappear with the kids. You're effectively resident parent. If you become resident parent, you control the game. What do you make of that, Mr. Ryan?
I don't disagree with that, he said cautiously. Yes, I don't disagree. It is difficult when you start to see that, if you start to see the writing on the wall in terms of your relationship. There is a reality that says that both parties, when they start to think, this is coming to an end, both parties do start to shore up their position and start to prepare themselves and start to, build the battlements by which that they will go forward. At some point, you are going to end up probably in a court, and at some point you're going to end up arguing over finances, and you are going to have to demonstrate that you made an equal or indeed a greater contribution to the financial matters within that relationship in order to give yourself a decent position. What type of receipts do you recommend you keep? I mean, bank accounts tell all, to be perfectly honest. All of us live these days by using our phone. We very, very rarely use cash. And if we are using cash, it's because we're hiding something. So usually bank accounts are pretty revealing in terms of what's going on, both your bank accounts and the other party's bank accounts. So there's not a huge need to sort of be saving anything in particular. Just be wary of the fact that at some point, a court is going to say to you, or a solicitor is going to say to you, show me your financial life for the last 2 or 3 years. Be aware of that.
Also, I'll suggest one more thing. Yeah, if you feel the end is near, make sure all your bank documents, all your personal documents, your finances, make it disappear. Make all your paperwork disappear. If it's laying around and you end up outside the house, they've got everything right there. So my suggestion is, off the record, again, get all your paperwork out, make it disappear. It doesn't exist. It's not in the house. They can't access it, number one. Number two, I mean, I say this like it's easy. When you're in this space and you think the end is near, you're emotionally, you're up and down. You don't know where things are headed. You're unsure. You don't know what to do. It's a very difficult thing to do. But knowing the horrors on the other side that I know, I would say take the children and aim to become the resident parent immediately. And that's what you do by taking charge of the situation. And that's when you're ahead and then the other person is fighting for access. That's the only way that I can see you can pull this off. Yeah. Right. Yeah. What do you think? God, any more to add to that?
Yeah. No, as I say, I'm cautiously in agreement with that. But the one thing I will say in terms of when your relationship is coming to an end, joint bank accounts. Be aware of them. Be aware of what's in them. Be aware of the fact that one side is going to try and empty them. So just be aware of joint financial arrangements. So joint bank accounts, joint insurance policies, joint pension schemes, that sort of thing. Because I say they are going to be targets. Just be aware of that.
All right, I'm going to reel out a couple of more questions from the same chat, Dan. If you could just give a little brief on it. It might be too much to answer here, but if you can touch on it, right? What is the best way to protect assets in a divorce? It's a common question. In short, is it possible to answer?
Very common question. The best way to protect your assets is to be aware of them. To be honest, to be aware of what it is that you have got, and if there's something that is solely yours or solely in your care, because it's your personal bank account, it's your insurance policy, it's your pension scheme, just ensure that whatever paperwork you, just as Farook has just said, any paperwork that you've got in relation to that matter is put somewhere out of reach. Whether that's moved away to a relation's house or whatever, just put somewhere out of reach, because the other party is going to go looking for it because they want to use it against you. So your own assets, make sure that the paper trail for those is out of reach in order that you have access to it, but the other party does not. Physical assets, there'll always be an argument over them. So arguing over cars, arguing over the house, unsurprisingly, arguing over the caravan that you've got on the drive, whatever it might be. Very difficult to protect those. They are just going to boil down to a fight at some point.
Or what happened is that, as you know, if mother's not in the house, she'll come with police assisted, load of friends. This is a common pattern that I keep hearing. They'll come and strip out the house at the first opportunity. And I've heard it on so many occasions. They've even taken the toilet brush. Not one case, listen, many cases that I've heard, they've even taken the toilet. This is a common theme. And this is where you need to be alert and sharp and be honest. If you're watching these streams, you guys will be ready for this. You ain't got to go through some of the stuff that we've seen and heard and been through. So if you watch these streams, you will be aware of how to avoid these things. But chances are, like Mr. Dan said, there will be some sort of a play for the assets, including the petty stuff, a toilet brush, and other small petty things. But look, I say with these little things, it's collateral damage. Don't worry too much about it. Do you know what I mean? Keep strategic, keep your eyes on the prize, the bigger goal, the bigger picture, the bigger vision. Quick question from him again. Let's wrap these up. If an allegation sticks, can you lose your job?
No. And I'll tell you why. In fact, fact finds are part of family law. Family law is in the family court. The family court is a private law matter. What does that mean? What that means is that the family court essentially is two people who are having a row. And the family court is providing the arena for that row to play out. But that row is entirely private. It has no premise out in the wide world. So if you get an allegation blasted against you in a fact find in the family court, that allegation is private. It stays in the family court. It does not go out to be handed out to the police. It does not go out to be handed out to your employer. That is outside the rules and regulations of the family court. It is a private matter. It stays private.
Okay, just a reminder, just remembered after that last question, going forward, me and Mr. Ryan at some point will be doing a live stream on financial orders and how to protect your assets, just the whole financial side of stuff, how to best protect yourself. We will be doing a stream on that in the future very soon to cover all of that in more depth.
Yep.
Jump on to the next question. If you went back to family court for more time with your kids after the final hearing, is there a risk that the judge might take time off you if your ex makes false claims that the kids doesn't like being with you when you have contact?
Yes.
There is a risk. Okay.
There is a very distinct risk. There's also a risk, obviously. Well, there's also a distinct opportunity that you'll get what you went for, which is to try and get more time. The reality is, when you go back to family court, whilst whatever has happened in previous proceedings will be pulled into these proceedings, the playing field is level again, which means that each party can bring allegations against the other. Each party can say, oh, well, yeah, well, the reason this isn't happening is because the kids hate him, because the kids don't want to see him, because the kids don't want to see her. So, yes, there is a distinct risk that you need to be aware of, and you need to mitigate that risk. But you can go back into court with a family order and leave with a worse one.
Okay, fair enough. That's a new one. Yeah, I was aware of that, but okay, that's good to keep in mind, I think. Before we get any further, shout out to Omar getting them pips, my guy, my trading friend who's watching the stream live. So shout out to him, respect to him. Move along a little bit further. Right, HG, if you take the kids and become resident parent, the children will still need to see the other parent to voice something refusing to return children. Right, listen, HG, this is a game of strategy. It depends on, unfortunately, when you lose contact with your kids, when you've seen these horrors and you ain't seen your kids for a while, it will throw you into an emotional roller coaster. So when I say this, I'm saying this from a position from the other side. So from your position, if you're not there yet, I can understand where it seems like a very bold, brash, serious thing to do, try and become resident parent, take your kids for a little holiday and disappear. It sounds like a very serious thing to do. That would have never entered my mind. If someone said that to me, it would have been in one ear out there. I couldn't have done it. But now that I'm on the other side and I've seen the horrors, when you ain't seen your kids since, right? You realize what lengths you'd have been prepared to go to if you knew what the situation would have been. When you've been cut out of your children's life, like I said, you don't see the world in the same way again. The whole world that you do has changed. Hence, I can say this to you now, to make that move, you got to take charge of the situation. You know, and obviously from your position, it seems quite a very serious, aggressive thing to do. But listen, the pain and the damage and what you're going to go through on the other side is a living hell. To avoid that living hell, you got to do something. It's like you have to have faith in what I'm saying and do what I'm saying. Otherwise, you'll end up in hell. It's the unseen. I'm telling you, the pain, the horrors are unseen and unfelt, and it's still hidden from society, hiding in plain sight. That's where I'm coming from. So look, the little nuances of it, we can work out if you're serious, but understand what I'm saying, man. When you don't see your kids, when you lose contact with your kids, your whole world will go upside down. There's men unaliving themselves every single day because of this. 10 men a day post-separation. You've got to ask why they're doing it and how much of a horror story it is. Sorry about that. Let's move along. If an order allows me to, right, here we go from essay. If an order allows me to the school under written head teacher permission, how do I navigate if my child asked on video to come to sports day, but mum has alienated school and staff?
Always difficult. It's all because invariably mums take their children to school and they have a greater relationship with school than most fathers, and that's there's nothing wrong with that. That's just reality. And that's just a societal issue. It is always difficult because mum, every time she spends 10 minutes on that playground, will be feeding the school and will be feeding the school staff about who you are and what a dreadful human being you are. Your stance has to be a simple one. If you've got an order, which you say you have, if you've got an order that allows you to go to school under the written permission of the head teacher, then you contact the head teacher and you say, I've got an order. I presume he's got a copy of it or she's got a copy of it. There's a school sports day coming up. My child would like me to go. I would like to be there. Now, do we manage that in order that myself and mother are kept apart from each other, that the children don't get upset, the situation doesn't get ruined, that the event can go ahead? And a professional head teacher should manage that environment because it is important for both parents to access their children.
But the thing is, Mr. Ryan, normally in school, there will be a welfare teacher or a welfare officer. She takes care of it, not the head teacher. And I hate to say it, the welfare teacher works closely with social services and CAFCAS. And I hate to say it, SA, but in my experience, they're all in on it. Unfortunately, I'm sorry to say.
No, I take the point. Often the pastoral care team, will take the side of the parent that they see more often. That is often the case. You've just got to push. Yeah. Look, I'm sorry, but I'm entitled to see my child.
It's difficult, but yeah, you got to push. Right, next question, Dan, because they're still coming in. I'll quickly try and fire through them. From Ahmed Ali, can they show the fact find to kids' school?
No, they can't. Fact find, the outcome of fact find is private. What happens is that the results of a fact find are shared with CAFCAS. Sometimes they are shared with the local authority. If they are grave enough, if they're serious enough, they may be shared with the local authority. They aren't shared with the children's school directly, but the children's school may be invited into potentially into a child in need plan situation. They won't be given the details of the fact find, but they may be told that there is a situation whereby there are findings against one parent or another. So, going back to let's try and avoid fact finds if we can. They can creep. The fact findings and the findings that are labelled against you and the bell that is hanging around your neck, that will creep. And it creeps out to social services, and it can creep into your children's schools, and very quietly by back doors it can creep into your employer before you know it. So be careful.
So it goes back to the school. The welfare could creep in from social services, CAFCAS, to the welfare teacher / officer in the school. Right, let's move along. Another question we got. Where are we? Right, from Kashi Patel. Mr. Patel, how does the court determine if a case needs to be made public? What are the triggers?
Okay, so family law deals with public law and private law. And as I've said already, Private law, which the bulk of family law cases are, is essentially an argument between two parties, between a mum and between a dad. They're having a fight, and they just need the family court to effectively provide the ring. If children are potentially at risk from both parents, if there is an undertaking, if there is a view from CAFCAS or from a local authority that the child or the children is at risk from both parents, the matter then has the potential to be made a public law matter, because the court will then need to start to consider whether those children should be taken into care. So the trigger, to answer Kashi's question, the main trigger, the primary trigger for moving from private to public is there a risk, a very real risk, that these children are going to be taken away from both of their parents and placed into the care system. That is the trigger to the public.
Okay. Right. Mr. Ryan, I'll keep going through as time is ticking along. Right. Ahmed Ali again. Son's school blocked me from accessing the school file. They are not responding to emails. What are my options?
You just need to keep pursuing it. Go above the school. Go to the educational authority, which obviously are within your county court. Within your county council offices, there is an education department who manage the school. So if the school is ignoring you, go to the educational authority and raise your issue there.
Right, Mr. Ryan, as time is ticking along, I'll give you the floor again. You can finish up or continue as much or as little as you want about the fact find, and try and maybe bring this towards a close. We won't get around to all the I've got questions on Instagram and WhatsApp. I don't think we're going to get around to all of them today. It's been a busy night, but listen, I'll give you the floor, Mr. Ryan, to take it whichever direction you want.
Okay, so as I say, we were exploring the fact find. I'm just kind of giving you where it is. So this is what happens after it. So I'm taking on board my point that it needs to be, the court needs to see it as being proportionate. The court needs to think, well, if I do this and I find out whatever I'm going to find out, is there a value to that in terms of the children? Because that ultimately is what we're here for. So they do the fact find. There are findings. There are always findings. There's never, ever, since the history of the birth of man, has ever a fact find got away with no findings. The judge feels compelled to make a finding, or at least one, because otherwise, what was the point? So there will be findings. Those findings are then handed to CAFCAS. CAFCAS invariably, or sometimes to the local authority. If the local authority have been previously involved in the matter, which sometimes they are in place of CAFCAS, the findings will be handed to local authority. And the local authority or CAFCAS will then carry out invariably a Section 7. And the Section 7 is right. So now I know who the bad guy is. Now I know who the evil lady is. What am I going to do about this in terms of these children? What is the impact of us now knowing that one or both of these parents are domestic abusers? What is the impact of that on the children, and where is that going to take me? So they will complete a report. That report will get submitted back into court by way of a set of recommendations that says, off the back of the fact find, off the back of the fact that we now know that dad is a horrendous human being and mum is a horrendous human being, this is now our recommendation as to what should happen in terms of the children. Now then, let me tell you this. If you get findings against you, at the end of the fact find, there is a tiny possibility that your contact arrangement that you had the day before the fact find will end. Because the judge will immediately say, well, I appreciate that the day before yesterday, you were seeing your kids 3 times a week and they were having a great time with you and you were having a great time with them. And that court order has been in place for the last 18 months while we've been fighting this matter out. We've never had any issues with it. Here we are now at the end of the fact find, and we've now decided that you're a domestic abuser. We've now decided that the allegations against you are true and you are a domestic abuser. So, unfortunately, while we thought that you were okay to have your children the day before the fact find, here we are now at the end of the fact find and you are no longer okay to have your children. And you will find your contact order potentially can get completely destroyed. You'll find that potentially you're in a situation where, I'm going to come into Farook in one sec, but potentially you're in a situation where you're just going to get handed indirect contact. You don't get to see your children. Farook.
Right, I've got someone there to come onto the stream, so I'll bring them on, see if they've got a question. Yeah, someone coming on live. Right. Ben, Ali, I'm bringing you on live. Ben, tell us your situation.
Hi guys. Just to let you know, I was essay in the comments. I just want to say I really appreciate all your effort and time for all the people in the stream, and I just have a few more questions. Because the answers you gave me, it made me have more questions, if you know what I mean. So if you allow me, I'd much appreciate it.
Yeah, no, listen, man, ask your question. As you join the stream live, we'll give you a bit of time, do your thing, ask your questions.
So to cut the long story short, I have 2 children, aged 5 and 6. To fast forward time, in the DRA hearing, I had basically a ruling that allowed, and just to give you a little tidbit on this one, guys, I was lucky because the judge saw my evidence first. So the email of the respondent, i.e. my ex, somehow her evidence and her email didn't get through. So the judge saw mine, and it kind of, because it's a cowboy situation, like you guys said. So he basically forced the court to be paused so I can basically have a negotiation with the lawyer. So the lawyer, I just said, you know what, I'll just have some video call. So on the DRA, the judge ruled indirect once a week video call. I'm experiencing some issues with that. Basically, obviously the kids are saying bye without them wanting to say bye. They're cutting off the phone. And I got an interesting email from the lawyer, kind of like a threat, saying that you're asking too much questions about what they're doing with their mum and what they're doing with their grandmother. And they're also insinuating that my daughter now is getting distressed in school, but then they haven't got any clear evidence to suggest that my video calls are resulting in her behavior. But they're insinuating that it's the video calls, but there's no evidence of admission for my daughter in the school to say, dad's video calls are causing this. This is why I came up with the question, with the sports day question, because I have my PTR in December, in fact find hearing in January, and I wanted to see if I could attend the sports day, but as the brother Farook said, that it's unlikely, because if they've been fed information, the head teacher might just say no, even though there's a court order to say within a period outside the school hours, if I get written permission, I can come in person. But I've not seen my kids since July. So my question is just that, if you got any information, if I say no, is it okay for me to then ask them, so what do you expect me to say to my daughter or my son? And I have just the last question would be, obviously I have a fact-finding hearing in January. So from what I gathered, the woman that came on, I really appreciate her advice. Are you basically saying clearly that when it comes to the fact-finding hearing, I can't avoid the fact-finding hearing at all, even if I propose that I follow the orders and it's not necessary in order for what I propose in regards to, I've not caused the children any harm. I'm not a threat to the children. I just want to go with the recommendations of CAFCAS for the Section 7. I just want to clarify on that one. Thank you guys for your time.
Okay. Dealing with that one very quickly first, Ben. The court has decided now that you're going to have a fact find, and I'll just say how incredibly sad that your fact find is not until January. Your fact find is in 7 months' time. And I think you said you haven't seen your children since July, which I surmise is last July.
Correct.
Which means you'll be at the thick end of 18 months before you even get to a fact find. And that is just the state of disrepair that the court system's in currently. And that is, we are destroying childhoods as a result of how it is that we're conducting ourselves in family court currently. But you are too far down the route now, because a judge has decided that a fact find is proportionate in your matter. So even if you went back to that judge and threw yourself on your knees and said, I will live by the rules now, she has already made the decision whereby they believe a fact find is proportionate, and so you are now locked into that. And unfortunately, now time will now pass. Ridiculous amount of time will now pass until such times as that can be addressed. Your ability to do anything in the interim is very difficult. Video calls are the world's worst, because the video call is being controlled by the parent who has got the child with them, and they decide whether it's a good call or a bad call. They decide whether it's a short call or a long call. They decide whether the content on that call suits their purpose or suits yours. So you are being controlled. You are being controlled by what is happening on those video calls. You have to be patient. If you get to a point where your video call is fundamentally being frustrated, i.e. it's not happening or it's being deliberately cut short, and you can demonstrate that, and I'm not suggesting for 1 minute that you might record a few of these calls, but that's something you might think about. You can then make an application back into court, because it is a court order that says you have a video call. If that video call is not happening and not happening in the right spirit, you have the opportunity to take that back to court. I'm going to jump into the comments, because there's some comments popping through from Tony, and Tony is answering my questions for me, which is great, really. I should put him on staff.
Yeah, thanks, Tony. Nice one, Tony.
Yeah, so Tony's absolutely right. For Beam, we were talking about measure orders, and Tony's absolutely right. If your ex can't raise the borrowing capacity, then unfortunately the house has to go. That suits you. So, as I say, in that respect, Tony's absolutely right, that she will be forced by the court to sell the house, and in order to move to something that's more appropriate. And again, Tony's most recent comment, and we all echo SUK's comment about Ben. Ben, you're in a difficult position, but I'm going to pick up on Tony's comment, where time is your biggest threat, and you're absolutely right. Time in the family court will destroy your relationship with your children. And that's out of your control, and that's horrendous. And I, along with undoubtedly hundreds, maybe thousands of other legal representatives in this country, write to the family court regularly and say, we just have to do something about this, because we are destroying childhoods. And childhoods are somewhere between 10 and 15 years long, and then they are gone. And we are destroying them because we are chewing up vast proportions of those childhoods with the delays in family court. And that is almost criminal.
Ben, does that answer your question?
Yeah, guys, I appreciate it. Just the last thing, you see, I got a very strange email by the lawyer in regards to video call, essentially like a light threat to say that what you're doing is causing distress. If this continues, my client might have to consider this arrangement. And hand on heart, all I talk to the children. One of the points which is what I need your advice on. My children ask me regularly to see, a lot of the conversation is reminiscing on the past. A lot of the conversation is about, Dad, show me the video, show me the pictures, the baby ones. She put specifically in the email to say, this is causing the distress, this is causing the children distress. And it's very subjective. There's no verbal admission from my daughter in the school to say that, but they're trying to also link that to the school, and that's putting me at a disadvantage to ask the head teacher to maybe attend sports day. So all these games are being played, and I've heard Farook in previous podcast, he's explained that there's a lot of games. So any advice on that before I go? Thank you, guys.
It's video calls are so difficult, because you do have to be very careful what you say, because you will be accused. So look, here's a picture of you when you were a baby. That can be deemed to be emotional abuse, because you're reminding a child of a time when they were with you and they're not with you now. I went to Alton Towers the other day. You would have had really great fun with me. That's emotional abuse, because you're taunting the child with a situation that they couldn't have. Dad, do you remember when we did this? Tell me about that again. And then you start to tell them a story about something that you did when you were together. And that's psychological abuse, because at that point, you're abusing and taunting the child. Video calls are so difficult. My stance on video calls is always, you have to talk to that child essentially about stuff that doesn't matter. Because the stuff that does matter, like the fact that I miss you, the fact that I love you, the fact that, I hate the fact that I'm not with you, that we're not doing this together, that we had a lovely time when you were born and for the first however many years of your life, all of that stuff, which is the stuff that matters, is the stuff that will get thrown back at you across a courtroom, and you'll be told that you are abusing that child emotionally and psychologically. So you have to keep your video calls bland. How was school today? What did you do? Have you been out to play? Are you playing on Roblox at the moment? What are you watching on the TV? It has to be bland stuff. And that's equally destroying relationships. And unfortunately, that's the downside of video call. But you will get criticized. If you engage that child in a conversation which is about real, this is about a real situation, like I want to talk to you about how much I love you and how much I miss you, that will be thrown back at you in a court.
Thank you so much, guys.
I think was Ben, no worries. And what I say to Ben and everyone else again, look, record everything, record all of this, record the calls, and just keep at it. I think keys. I don't want people to feel too negative about this. You just got to keep chipping away. Because what happens is with these video calls, you get emotionally drained because you're in that roller coaster, and then eventually fathers give up. If you can separate your action from your emotion and just keep chipping away. So as bad as a video call is, smile, nod along, record it. If there's a discrepancy from mum or mum's side, evidence, just record it, build a case. Like I said, it's not a sprint, it's a marathon. You know you're in it for the long games. 18 months, 2 years. I know guys that are still going for it 3, 4, 5 years. So the key is just keep chipping away. I know guys that after 4 or 5 years got access with their children, but they never gave up. They just kept chipping away. So it can work. These games are going to be played. You will be tested emotionally. Your character will be tested. Your heart will be tested. But you just have to keep going. In these dark moments, just keep chipping away. Ben, appreciate you coming on. We got someone else, Mr. Wright. I'm going to bring him straight on, as he's dialed in. Right, Omar, what's happening?
Yes, Omar. Farook, how are you? Okay.
Yeah, I'm good. What's happening, bro? Are you okay?
Good, man. So I just got a question, right? So I'm just learning more about this, family court system and stuff like that. So I'm not married or anything. So later on, when I do get married, I'll be, informed about all of this sort of stuff. Yeah. So the question is, you see the nikah marriage, right? That's not considered a UK government marriage.
No.
So that's what I'm planning on doing. So is the court case? Am I going to go into court cases and stuff like that related to that?
Yeah, that's just what you got to look at. If you just get nikah only, so let's say you just get your religious ceremony, and this thing is this. So even with this, the gurdwaras, the Sikh, the Hindu temples, the gurdwaras, and the mosques, a lot of these places are registered as religious institutes, just like a church. And a lot of these places, some mosques aren't, they can still get away with it, but a lot of them are now being pushed by the government, by some lobby, by whoever is controlling all of this, to now when they perform a nikah, it's automatically registered. I know with the Sikh temple, the Sikh gurdwaras and the Hindu temples, they're pretty much signed up with the council as a religious institute, and it's automatically, it goes in as a registry. What you got to do is, at your house, you do it privately. You do the nikah private. So you have the religious ceremony in your house. You call the priest, the mulana, the pandit, whatever it is, to your house. He will read you your religious rights, and you keep it simple. The place where the family court get involved is, the thing is, inevitably, if you're married, I presume you're going to have kids at some point. Now, when children get involved, you will still get embroiled into the system. And what the people have this misconception is they're financially completely safe because they're not married. You have some protection, but because you have children, you can still get embroiled into the system because you're connected via the children.
Okay. So they can still do you over through that way as well.
Yeah, it's not that simple. Look, every case is different. There's a lot of different nuances and angles. And because you're not married, you can put things, look, you can only have your assets at risk, for example, if you have assets. Are you following me? There's no assets in your name. You have nothing. You live in a rented property, potentially, say for argument's sake, then your pot is very small. So you're limited to what you're going to lose, other than potentially your child access. That's your biggest concern, because any breakup, look, there's 3 aspects. There's the child access, the emotional damage that both parties are going to take. There's the child access, the financial aspect, and there's the living arrangements. You could potentially be homeless. So these are the factors you need to consider. Mr. Ryan, is there anything you'd like to add to that?
All I'll add to that, Omar, is that if you have a religious ceremony, regardless of which faith it's in, and you don't register it in the UK, and Farook's right in what he says, that a lot of the mosques and the gurdwaras have now signed up to automatically registering marriages in the UK, but there are still some that aren't doing. So if you don't have your marriage registered in the UK on a UK register, the only issue that presents you with is, come the day that it ends, And I trust it doesn't, but we live in a real world. So come the day that it ends, in terms of UK court, you will then be dealt with as a cohabiting couple. So you don't divorce as such, because you weren't married as far as the UK is concerned, but you still have a financial relationship. You could still end up in a family court dealing with your financial relationship as a cohabiting couple who are trying to split their financial affairs. It's fairly straightforward, but just be aware of that as a potential risk.
So who would be paying for that then? So let's say, for example, we've split up now. So for the family court proceedings and, to make payment to the, the court system, who's going to be paying that then? Because myself, I wouldn't be trying to entertain that.
It boils down to whoever's going to take it into court. Whoever buckles first and says, I'm going to court with this, they will
got the kids. But when it comes down to whoever's got the kids.
Okay.
This is the nuances, Omar. You got to understand, there's a lot of different angles to this. Look, if you both just got together, you're renting a property, you split, it's minimal damage. The key is this: if you've got a kid, you've got kids, and this is where it gets complicated. And she's, as I mentioned before, the person who takes control of the kids, who takes charge of the kids, controls the cards. They control the game. So if she's taking the kid and she denies you access, being a woman, calling the police, saying she feels threatened, you ain't going to see the kids. You're going to then have to take it to court to see your kids. As much as I don't want to entertain the family courts, but at the end of the day, I owe it to my kids to try. I have to know I left it all in the ring. So I have to then enter the system, or from day one, it's very difficult to do the surrender tactic from day one, because you're new to all of this, you're new to child contact, you don't know what's going on, you're emotionally damaged, you're taking emotional damage, you want to see your kids. Hence, you will then, this is when fathers go to court, they have to do the application, C100, whatnot, child access application, and that's when you can get fleeced, and that's when you enter the system ultimately. So it depends on the scenario, it depends on which angle you're coming from. It's not as black and white as, well, I'm not going to entertain the court, so I'm not going to go. It depends on the nuances of your case ultimately. Does that make sense, Omar?
So you're saying, it's a lot of the times as well, it's going to be in favor of the woman as well when it comes to her trying to take the kids and stuff like that as well.
But that's society's position
to get them back.
Yes, societal position is 90% of the resident parent are mothers. Mothers instinctively know how to take control of the kids. Mothers, in all the cases, all the fathers that I speak to, a few mothers as well that are, unfortunately 10% of non-resident parent are mothers. Let's highlight that as well. But majority of the cases, it's an instinctive thing with the mums, the schools, the other school mums, where they seem to instinctively take charge of the situation. They know what buttons to press. They know what buzzwords to say to take control and charge. And if you watch the other streams, Omar, when you get a chance to watch some of the other podcasts and streams, non-molestation orders, occupation orders, how this is done. So if you understand how all of this is done, maybe then you can avoid it. But I think you need to go back a few steps, watch some of the old streams, watch some of the longer podcasts, and all the information you need is on the Disqualified Dads YouTube channel, and all the podcasts, everything we've talked about from start to finish. There's so much information on there. Just watch all of that. It'll give you more of an insight, and then we can drill down further if you've got more specific questions going forward. But listen.
I appreciate it.
Make yourself aware, Omar, yeah?
Thank you so much for
Thank you for joining the stream, Omar.
Again.
Take care, Omar.
Thank you, Omar. Speak soon, Omar. Right, Mr. Ryan, shall we try? Are you okay for time, Mr. Ryan?
I'm okay. I think we've got a bit of a backlog of questions. If you want
Let's give them, because there's still almost 30 people on the stream, so that they're listening, they're interested. So let's give them as much as we can. Yeah.
Blast through some of these questions.
I'll go back a step. Tony has answered some of these questions for some of the other chaps. We stop Beam. Right, let's go back to Beam. Yeah, I don't know if you answer with the measure order. What other option is there if my ex's borrowing capacity is too low to take over the mortgage solo? Tony has said she needs to sell and move to a smaller property.
And he's absolutely She'll be ordered by the court. She can't walk into the court and ask for a measure order and then not be able to demonstrate how she's going to pay for the house, and she can't expect that somebody else is going to pay for the house for her. So the court will just blow that out of the water and say, no, I'm sorry, the house has got to be sold. So that's what we'll do in that case.
All right, fair enough. Right, I've got Anton the Prodigy.
Yeah, Anton. I was looking at Anton. comments. So Anton says, what I'm hearing is that everything is abuse. And don't talk to your children. And then who created these bullshit views in the family court? Well, Anton, you're right. You're right.
I agree, yeah.
When you enter court, when you enter the family court, everything is heightened. Every comment that is made is taken up a notch. Everything you ever said is misconstrued. Everything you ever did is misconstrued. Welcome to the family court. Because you've got two people in this private row, this private argument, this private dispute that they took into family court. But the moment they step into that room, it moves from being an argument to being a war. And I have sadly found over the years that I've been doing this, that as proceedings go on, because they take so long, and that's not helping, that is feeding the hatred. But as proceedings go on, parties become more and more extreme in what it is they're prepared to say and what it is that they are prepared to do. And they will they weaponize their children at a very early stage. The children become a weapon that they can use against the other party. But they start to say the most extreme things, the strangest things come out of people's mouths as to something that they suddenly remember. We're 18 months into a set of proceedings, and they suddenly remember that 7 years ago you raped them. And they've just remembered that. They haven't remembered it for the last 18 months, but they've just remembered it now.
Yeah, careful with the R word, Mr. Ryan. Not too much of the R word, yeah.
Apologies, everyone.
YouTube,
But because there are too many people thinking, hang on a minute, I'm heading towards a lose here, so I need to ramp this up. So unfortunately, you're right, Anton, and unfortunately, I apologise that that's the case. But you are right that everything that is said in family court can be construed as abuse. And you need to be aware of that, and you need to reflect on what it is that you've done in the past, and you need to be prepared to answer to what you've done in the past, to something that you think is completely trivial, because unfortunately by the time it gets into family court it will become a major drama.
Right, move along. Tony has said, right, Anton, how do we fix this apart from just accepting it is what it is and just play the game?
Yeah. Well, there you go. You play the game. You accept the fact that the family court is a theatre, and you are playing in it. So you need to ensure that you have a damn good script, you have a damn good story, but never lose sight. And this kind of picks up on Tony's point, the next point down. Never lose sight of the fact that the reason we're in there invariably is because we're trying to rescue the childhood of our children. And the other side that you're fighting against, be that mother or father, may not have that objective. Their objective may be just to destroy you. But I say to anybody who goes into family court, never. And I appreciate it gets frustrating and it gets aggressive and it gets upsetting and all that stuff. Never lose sight of why you're there. And you're there because you brought some children into the world, and they deserve to have a great, pretty flawless childhood. And you're responsible for doing that.
Yeah, and also, Anton, I would add to that, look, you always just hear the horror stories. Family court can work if you're strategic. You accept that this is a marathon. You shift your position emotionally to say, look, the rules of the game are not great, but if you chip away long enough, you can get through, you can win, you can get results. It's only the horror stories that seem to make it out more and more. Bad news travels fast, bad news sells. Hence, you don't hear of the success stories. There are a lot of fathers who I know that have eventually won and got full custody, let alone access. So it can work. It can, you can win. What they want is for you to get like this so that you give up. You think there's no point, and then they won. Key is shift your position emotionally, separate your emotion from action, keep chipping away. It can work. Let's move along. There's a comment from Anton. Same with domestic abuse. Everything is abuse in hindsight. Asking her to turn off the lights to save money, that's coercive and financial control.
Yeah, no, you're absolutely right. What the watch? What an interesting name. But no, you're absolutely right. Everything is heightened. Everything is heightened.
Right, last question, or a couple of questions come in. Right, from SA again, he's saying, just a quick one to clarify with Mr. Ryan about the video call. If child asks specifically for old pictures, videos to be shown, and I do, that is not classed as abuse, is it? Right? Question mark.
Were you and I in that video call with that child, when that child says, Dad, can you show me those pictures of when I was a baby? Can you show me the video of, us in the playground when I was a toddler or whatever? Between you and that child, that is absolutely not abusive. But this is what will happen after that. Mother will say, as soon as the video call was finished, the reason I had to close the video call early was because the child was getting upset, because the child was getting distressed by the fact that the father was showing them images of their old life. And that's what will happen. And so you have to be awfully careful. And I can never advocate to people that they should video their videos. But there will come a time where, particularly if you end up back in family court, there will come, and you're in the minute. There will come a time where you're asked to justify your video calls. And if you can demonstrate that with some very clear footage that says, look, here's me, here's my child, and we're talking about stuff, and we're looking at an old video of playing in the car, in the playground, or whatever it might be, then the court then obviously sees it from your perspective. Because currently all they will have is mother's perspective, which is the child gets so distressed because father just keeps ramming these memories down her neck or his neck, in order to distress them. He's doing it deliberately. You just have to be cautious. With video calls, you just have to be very cautious. And as I say, I'll make the recording comment again. You just have to be cautious when it comes to video calls.
Yeah, play the game. Strategic, remember. Play the game strategically. Don't get drawn in. Right, next question, Mr. Ryan. Do you think legal aid will be made to fathers again?
The legal aid system is a mess. The legal aid system is a absolute car crash currently, along with most of the other things that are coming out of Whitehall at the moment. And I'm sure it'll all be sorted out in the current election, or not. At the moment, there is an inequity in the legal aid system whereby mother can apply for legal aid and almost guarantee getting it. Father applies for legal aid, even if father is suggesting that he's a victim of domestic abuse, and his chances of getting it are pretty much stacked against him. That is a fundamental unfairness in the legal aid system. It requires, not just within family law, but within the whole legal aid system that covers the criminal law system, as well as it does family. That whole system needs to be revisited, and the boundaries and the criteria of that system need to be reshaped, because currently it is so far from being fit for purpose that it's a disgrace.
Well, so much for equality. Right. Final got a question here from HG. Would putting your assets into your mum's name or someone else's name before end of marriage work in protecting your assets?
If you do that 3 years, within 3 years of ending your marriage, so that's some fairly careful planning. If you do that within 3 years of ending your marriage, what will happen is when you do a financial disclosure in court, it will become obvious that you've done it in the last 3 years. And then the court will refer to that as a culpable act. So they'll refer to that as something that you've done deliberately in order to hide your assets. And then they won't allow that. They'll then dismantle whatever you've done, and the assets will be back on the table. If you want to try and hide your assets, how do you do that? You either start to entertain a prenup, which are becoming more trendy. I'll use that phrase, becoming more trendy in this country. They are second nature in the US and in parts of Europe. But we're kind of cautious about prenups in this country, but they are becoming more trendy. So you can either put in place a prenup in order to protect your assets, but obviously that's got to be signed by you and your partner, your wife or husband. You both have to sign it and recognise exactly what it is you are signing. Or when you acquire an asset, you protect that asset from day one by it never entering your name.
Absolutely. Right, Mr. Ryan, as time is ticking along, do you want to finish up on the fact find and try and bring this towards an end?
Yep. So where we were in the world of fact find is so we accept the fact that if you're going to go into a fact find, you're going to lose time in your children's matter. There is going to be a delay because, if we use one of the examples we've seen this evening, we have a father on this link who's currently waiting till January for a fact find to take place. And that's a ridiculous period of time, because in that time, that is a number of days, a number of weeks that are passing by that he has no opportunity to do anything with his children. So the fact find, accept the fact, if you're going to pitch for a fact find, accept the fact that you're going to lose time. So it has to be worth it. Is it worth it for me to lose what essentially could be 6 or 7 months? And then, because at the end of it, I'm going to win something, I'm going to gain something, I'm going to put myself in a more positive position in terms of trying to sort my children out, which is, going back to my earlier comment, which is why we're here. So that's issue number one. Issue number two, be aware of the fact that if you can win some allegations, you're also going to lose some. So contemplate the nature of mother's allegations or father's allegations against you. Contemplate of those allegations, as Blondie, who joined us earlier, and she's absolutely right, Blondie, who joined us earlier, if you can counter those allegations, if you can dismantle those allegations confidently, because you've got evidence that suggests they are wrong, false, untrue, then great. In you go, because you're in a safe space, aren't you? But the reality is this. You are going into a room, and one man or one woman, the judge, is going to sit and listen. And they're going to listen to what you say, and they're going to listen to how you present yourself, and they're going to listen to how the other party presents themselves, and they're going to listen through the tears, and they're going to listen through the fact that one party turns up with a domestic abuse support worker. Wonderful piece of theatre. And then they will make a decision based on the seesaw. Remember the seesaw? It starts like this, and they only need to go 1 point one way, and that allegation is proven. The odds of that are pretty stacked. You need to be aware of that. And then you need to be aware that obviously beyond that, once those findings have taken place, what is the worst that can happen? And the worst that can happen is you can lose your children. You can lose your children for the duration of those proceedings, which potentially is going to be another year because of the way the court system is currently running. So potentially for a year, if you had contact before the fact find, you're going to have none after it. Until such times as Kafka's finished doing their bit, arrive at a set of recommendations that say, yeah, we think dad or mum should have a contact arrangement that looks like this. And then you have another issue, because the issue you then have is you're now a year down the road from the fact find. The fact find said you're a terrible human being. The fact find stopped your twice weekly contact with your children. A year goes past, two more hearings take place while we sort this matter out. We get to the final hearing. We're now a year since you last saw your children, and Kafka say, yeah, we've thought about it, and there's no reason at all why this man or this woman can't see their children. So that's great. But because he's not seen them, or she's not seen them for a year now, we now need to gradually reintroduce them. So we probably need to start with dad or mum going into a contact centre. Who's paying that? Going into a contact centre to spend time with their children, just so we can make sure the children aren't distressed, make sure they're okay. And then out of a contact centre, we'll then go into some short periods of time. So you can see them for 2 hours every other weekend, 3 hours every other weekend. And eventually we get to a point where he can have, or she can have, a normal relationship where the children come and they stop overnight, and you eat pizza and you watch movies and you do what you should be doing with your children. The problem you have is from that final hearing to that bit where you're doing pizza and movies is another year. Because that's the gradual reintroduction process that Kafkas will recommend. They will say you need to do 3 months doing this, 3 months doing this, 3 months doing this. Then eventually you get to pizzas and movies. 2 years has now gone past from that point where a fact find said, yeah, you're a bad guy, you are. You need to think about whether that's proportionate. And that boils down to what age are my children. My children are 14 years old at that point. Suddenly my children are now 16 years old and I've lost them. So think long and hard about the world of the fact find. Think long and hard. And I'm just going to pick up on Tony. I'm just going to interject myself now and pick up on Tony's comment. I say Tony's back in the room with us. Tony says, what a sad state we're in. I lost my beautiful children 4 years ago. There is also light, and your children, my children, will find me again in the future, and we all have to stay strong. And he's absolutely right. He's absolutely right. I'm acutely aware of Tony's case, and it was a horrendously difficult case. that was not helped much by the family court, predominantly because their hands were tied by a set of circumstances that are fairly unique to Tony. But it demonstrated that, you go into the family court believing they're going to assist you, and they become a party to a set of circumstances that ultimately destroy you. I made a comment the other day, and it was deemed to be quite a strong comment, but I'm going to make it again. I said that family court is about domestic abuse. Most of the issues in family court revolve around domestic abuse, one party accusing another. But in my view, because of the time delays in terms of the family court system, because of some of the decisions that are being made in the family court system, decisions that are either being rushed through lack of resource, or decisions that are being made because the individual making the decision hasn't got all the facts or hasn't got an awareness of parental alienation, I think the family court is guilty of domestic abuse. I think the family court is as much an abuser of childhoods and parents as the parents themselves. That's a terrible thing to say, because the family court is supposed to be there to serve us as a party, and currently it's not serving us in any measure whatsoever.
No, it is state-sponsored kidnapping, unfortunately.
Yeah, there's an argument for that. Yeah, children are being held hostage within the family court system, and yeah, it's a terrible place. It's so tread carefully. Bizarrely, people who come to see me, and obviously lots of people come to see McKenzie Picave, and the first conversation I have with everybody is, do you really want to do this? Do you really want to enter family court? And I'm in the business of being in family court. That's what me and my team do day in and day out, 7 days a week, week in and week out. But the first thing I say to every client who comes through my door is, do you really want to do this? Because this is what is going to happen. This is what this is going to do to your life and potentially do to your children's lives. And you need to think long and hard about that.
The thing is, Mr. Ryan, when people come to you, say they come to you to go family court, they've come out of desperation because they've already not seen their kids, hence. So, they say, I think it's not out of choice that people enter it. That's the only choice, unfortunately, they've got. This is the thing.
Yeah,
it's the only choice they've got. Do you know what I mean?
That's true, but the problem, they come, they come because they believe, and they're right to believe, and they should believe that the family court is a vehicle by which the family court is set up to serve them and to solve their issue for them, because the family court is a fair place, and it's a place where the law is practiced, and they come with that. And unfortunately, that's a misconception.
It's a pipe dream. It's a fantasy, and this is what I'm saying is. This issue with what you said about family court, again, this is why we're here. This is why we're doing all of this, because it's been hiding in plain sight for nearly 40 years. And people still come to you now with this bizarre pipe dream and this fantasy that's about the children and law and process and right and wrong. This is why we're here to expose it. It ain't. But guys, look, don't give up hope. Tread carefully. Keep battling. Keep chipping away. Anything else you want to add, Mr. Ryan?
No, just well, we obviously we thank everybody who dials into these chinwags, these chit chats. We value your questions, and we're happy to answer them, and I'm sure we'll be dialing in again fairly soon with to tackle something else. But I say this: we're, as parents, and I'm a parent. As parents, the most valuable thing that we bring into this world is our children. And when we strip away everything that we have, the only thing that should remain is our children. And currently we're in a situation where the vehicle that is set up to assist us in protecting our most valuable asset, which is our children, is not working for us. And it's not working in anywhere near the way it should do, and that's horrific in 2024. Try and safeguard your children, and remember, if you're going into family court, whether it's coming through us, whether it's coming through another McKenzie friend practice, or coming through solicitors, or however you're going, or representing yourself, never lose sight of your children.